Justice Kilbride's question earlier, the consideration that the defendants propose in this case, I think, is unambiguously insufficient, even if it was appropriate to consider. And absolutely, that would be a factual issue for remand. There's no factual record here as to even what all of those benefits were. And I'll note that the defendants do, in their briefs, cite New York cases under the New York's pension clause that do suggest that a collective bargaining agreement collective bargaining agent could bargain away the constitutional rights and vested benefits of the members it represents. Importantly, only the members the transit unions or the unions represent, not retirees they don't represent, or not employees not in their bargaining units. But because those cases fail to even acknowledge, let alone distinguish, the rules that a bargaining agent cannot trade away the vested rights of their members and should not be allowed to bargain away the constitutional rights without the individual consent of the members, I think those New York cases just got that wrong. In fact, in the Schacht case, that the dissent in that case was correct. And further, because the immediate vesting under the pension clause, there is no need for the collective bargaining agreements to independently express an intent to vest. But nonetheless, I think the agreements here do express that intent as the appellate court recognized. Section 20.12a expressly states that this benefit terminates when the retiree attains age 65, not when the collective bargaining agreement expires. And then, when you read that with Section 20.12c of the retirement plan agreement, which defendants ignore, that provision expressly makes eligibility for the benefit based on the hire date. Every employee and retiree hired before September 5th, 2001 will be eligible for the benefit. That's, interestingly, very consistent with the vesting rules under the pension clause, that when that provision was added to the contract, it eliminated the retiree health benefit only for new hires. And defendants' interpretation would not only leave that provision illusory, it would actually make it absolutely meaningless. If the retiree health benefit here expired within 2 years at the end of the term of that contract, it would be absolutely have no meaning that new hire hired on September 5th, 2001 would be eligible for the benefit, because they could not possibly receive that benefit before they retired. Not to mention, it just is inconceivable that that's what the parties would have intended, that thousands of CTA employees hired before that date who could not possibly retire before the expiration of the collective bargaining agreement would not be entitled to those benefits. And the Article 11 deferred vested old age pension that defendants relied on in their presentation here, I don't think changes the decision. That's the only provision that uses vesting, and that Section 11 section, as the appellate court recognized, actually makes sense that it used the word vest, because it was referring to only the situation where an employee, after 10 years of service, but is too young to meet the age requirement for retirement, they are vested for this deferred vested old age retirement allowance, so that they know that come when they turn 65, 30 years later, they're still entitled to that benefit. But as that provision makes clear, you get that benefit when you're not age eligible pursuant to the Section 8 normal retirement date pension, the Section 10 early retirement pension, or the Section 12 disability pension. None of those other pensions reuse the word vesting. And as even the federal cases make clear, you don't have to use the word vest to show an intent for the retiree health benefit to extend beyond the term of the collective bargaining agreement. So the appellate court correctly considered each of those provisions, and I'll note that as the appellate court's reliance on the Hockey decision shows, that even without the presumption that we think is correct, even without considering the pension clause principles that we think this court must, the provisions of the collective bargaining agreement here do show that intent to vest. Turning to standing, the constitutional protection for retirement benefits here is also why all the plaintiffs must have standing. We detail in our briefs the reasons why a duty of fair rep claim is not necessary, because our claims are not subject to a mandatory arbitration clause. But one simple fact above all other makes it necessary for the plaintiffs to have standing. The CTA did not simply make these changes through collective bargaining, but ultimately the General Assembly enacted the cuts through Public Act 95-708. Therefore, plaintiffs can restore their retiree health benefit to the status quo ante only with the courts passing on the constitutionality of the Act. Any other procedure would be futile. I'll also remind the court that their arguments would apply to the pension annuities as well. If the plaintiffs don't have standing here to protect a retiree health benefit, they would not have standing to protect their pensions at all, because they're detailed in the very same collective bargaining agreement and established through collective bargaining. The transit unions could bargain to eliminate their pensions entirely, and they would have no standing in court. And a union's discretion to choose to defend or not to defend the rights of their members to retirement system benefits cannot substitute for an individual right of action in court, because the unions, as here, might choose that other interests of their membership were more important than the constitutional rights or vested retirement system benefits of other of their members.
Do these CTA contracts, once they're negotiated, are they subject to a union ratification vote?
Yes, they'd be subject to a union ratification vote, but often, as in the case, as in this case, they're imposed through interest arbitration.
But these that are at issue are not subject to...
That's correct, Your Honor. The Ben Award is what made the change to the retiree health benefit here, and even that memorandum of understanding that we think creates factual disputes and cannot be a basis for a decision on a motion to dismiss, that certainly, it's certainly not in the record, and I certainly believe it's true, was not at all subject to any ratification by the membership.
But just to follow your argument, if I understand it, what you're saying, at least on these constitutionally, what you say are constitutionally protected rights, it would take the end of, if it involves 10,000 employees, CTA active and retired, you would be looking for 10,000 separate ratifications? I mean, to approve what the union negotiated, is that what you're saying?
Correct, Your Honor, and I don't even think just a simple vote on the contract would be sufficient.
No, I'm talking about a specific, ratification on this benefit, yay or nay.
I think that's correct, Your Honor, that an individual would have to, in a sense, be said, given the offer, here's your individual contract waiver to change your retirement system benefit in exchange for something else that was sufficient consideration. I see my time is up. Thank you, Your Honors.
Thank you.